Hey everybody, this is Christopher Small with CMS Law Firm. Today I wanted to hop on here and talk to you about why both parents need an estate plan, particularly if they are not together. And by the way, if this is you and you have more questions about this after you listen to this video, please go to estatemeeting.com, set up a time to talk with me. I can answer any of your questions, give you some more information, kind of go deeper on this with your specific situation. Okay, so this topic is actually born out of a will signing that I did for a client today. He is not with the mother of his children. We were doing his estate plan, getting everything signed, and we were talking about who the guardians of his kids would be if something happened to him. And as we were discussing this, an important question came up, and I just had to hop on here and talk about it today. So essentially, the way it works is, if you are a parent, whether you are married, together, or split up, or whatever, you are the presumed guardian of your own child, okay? Absent some very, very significant events in your life happening where that sort of obligation and right and what's what I'm looking for? And honor is removed from you, then you are going to be the parent. So if my client, for example, who is not with the mother of his children, if he dies, the mother is going to be the presumed guardian of those kids. No matter who he picks in his will to be the guardian, the mom is going to be the guardian. That's just the way it works, okay? So if that is you in your situation and you've been wondering about that, that's sort of the first rule of thumb. That's the first important thing to understand and know, all right? You cannot take the obligation away from your other parent, okay? I don't know really what to call them, but because you're not together, not significant other, not spouse, baby mama, right? Or baby daddy. So that is the first thing that you need to know. The second thing, so that sort of brought on this question by my client that sort of brought us here today. And that question was, so what if I die first? Then what happens? Does my baby mama need to have an estate plan? And I said, yes, she does. It's very, very important that she does. And he said, well, what happens if she doesn't? And I said, well, if you die first, and then your kids obviously go, they live with mom, and then if mom dies and she does not have a plan, it doesn't matter if you had a plan, their world is sort of thrown into turmoil. The reason is because she is the last one to die, they are going to look to mom's estate plan to see who the guardian of the children is going to be. And if she does not have an estate plan, then a court is going to pick, just like if both parents didn't have guardians chosen with their own estate plan. A court is going to pick. There is likely going to be some amount of time that child is with Child Protective Services. It could be short or long. That really is going to depend on the circumstances of the case. So I'm not trying to freak you out by telling you that. It's just the truth that it may happen and would likely happen for at least a short amount of time, particularly if there was no plan in place. And then the way that the guardian for the kids would be chosen would be anybody that essentially raised their hand and petitioned the court and asked to be appointed the guardian of those kids through the process of the mom's probate. Okay, so hopefully that all made sense. Dad dies first, and then mom dies without an estate plan. A probate would have to be opened in mom's name to then, nominate and name the guardians of those kids. So if you are a divorced parent, or not even divorced, just if you are a parent and you are not with the child's parent, the other parent, then it's really important to have a conversation with them about putting together an estate plan in case something like this happens. We all, I think, I would hope that no matter what the relationship was like with, the other parent of your child, you would be able to come together and have a conversation about this to make sure that your kids are taken care of. Okay, like I said, it was sort of a wake-up call for him today as we were sitting in the room signing his own documents. because he wasn't sure about the status of an estate plan for the other parent. And it's definitely a conversation that he's going to have, and it's something that was important enough that I wanted to really come up on here today and push you to think about that and have those conversations and take that action and put that plan together. One of the great things about estate planning, one of the reasons why I do this, is because this has real world results and has real world consequences for putting these things together or failing to put them together. Okay, it's really critically important that you do this kind of stuff, whether you use me or not. And by the way, if you would like to use me or would like to talk about this more, estatemeeting.com will do that for you, okay? That is it. To sort of summarize, if you have kids and you are not with the child's parent anymore, whether through divorce or breakup or separation or whatever else, it's really important to have a conversation with that other parent to make sure that you both have estate plans in case one parent dies first and then the other parent dies after that, to make sure that both parents have plans to protect the kids, name guardians, and ensure that everything goes smoothly in the event that tragedy happens. So if you have any questions, again, you can leave a comment down below. You can, Andrew, what's up? You can, if you like this, hit the like button. And if you know someone that needs to hear this, please share it with them. And again, if you have additional questions, if you want to know more, if you have a specific situation that you want to talk to me about, please go to estatemeeting.com and set up a time to talk with me. It's free. All right, that's it. Have a great night, and I will talk to you again tomorrow.